Hi, I'm John Robinson, SVP of Digital Media at CAMG, and today we're going to break down a critical regulation that's going to reshape how law firms manage prospective client outreach. The Federal Communication Commission's, or FCC's, one-to-one consent rule under the Telephone Consumer Protection Act, or TCPA. This rule is set to take effect on January 27, 2025, and its impact on how law firms communicate with potential clients cannot be overstated. I want to start with the basics. The one-to-one consent rule requires that consumers provide prior express consent to a business before they can receive any automated marketing communications like robocalls or text messages. This directly affects how law firms acquire leads from lead generation companies. If your firm relies on third-party lead generation companies, especially those using blanket consent methods, the stakes just got a lot higher. This isn't just a formality. It means if your firm purchases leads from a company that uses non-branded ads, co-registration marketing, or multi-select consent forms, you're risking non-compliance with the FCC's new rule unless each lead has explicitly agreed to be contacted by your firm by name for a specific service offering. The financial penalties for TCPA violations can range from $500 to $1,500 per violation, and those numbers add up quickly when you're generating a high volume of leads. Even worse, relying on blanket consent that doesn't specifically name your firm could open the door to lawsuits and catastrophic financial impacts. Beyond the financial risks, the reputational damage can also be severe. Imagine a law firm being subject to penalties from the FCC. Does not look good. Law firms need to understand that consumers are becoming more savvy about their rights to privacy and data security. Sending unsolicited communications damages trust before the relationship with the potential client even begins, potentially turning valuable leads into costly legal battles. Trust and transparency are really essential to converting leads into clients, and compliance with privacy regulations is a significant part of that equation. Let's talk about how law firms using lead generation companies can protect themselves under this new rule. First, demand that any company that you are working with that helps you generate leads obtains explicit firm-specific consent. If your lead generation provider isn't already getting TCPA consent specifically for your firm, you really need to rethink your relationship with them as this new rule rolls out in January 2025. Blanket consent is no longer enough. That has been the standard with TCPA over the past decade. Second, you really need to maintain airtight records. Your firm must ensure that all consents are clearly documented, including the exact date and time and manner in which the consent was given. Whether digital or paper, these records must comply with the e-sign Act, and they have to be stored for 5 years. You must keep record of consent for 5 years, or you could risk exposure. Third, make sure you vet your marketing vendors carefully. Not all lead generation companies are going to be able to be equipped to handle this level of compliance. It has become very technical in how this can be done. It's crucial that you work with partners who understand the new requirements and can deliver leads that meet the FCC's strict consent standards. Finally, I want to make sure you're aware that you need to train your staff about this new compliance. Everyone from your intake team to your marketing department needs to be aware of these changes to avoid any potential slip-ups. Ensuring full compliance is now a shared responsibility across your entire organization. Law firms have until January 2025 to get their lead generation strategies fully compliant, but waiting until the last minute is risky. The FCC announced this almost a year ago. Now is really the time to audit your lead sources, train your team, upgrade your consent procedures, and align your partnerships with the new regulations. Navigating the FCC's one-to-one consent rule isn't really just about avoiding fines, it's about demonstrating that your law firm respects the rights and privacy of the clients that you're trying to help. I want to thank you for watching. If you have any questions about the FCC's one-to-one consent rule, feel free to reach out. Don't forget to like, subscribe, hit the notification bell for more insights into the progressive world of legal marketing and to receive more digital updates from us here at Consumer Attorney Marketing Group.